Greetings. I hope that this video finds you and your family in utmost good health and in good cheer amidst these trying times caused by the coronavirus pandemic. This video is created for the benefit of my second-year JMC College of Law students in order to supplement the discussions on the rules on civil procedure, and likewise to speed up our discussions so that we would finish the subject matter at the soonest possible time to coincide with the deadline set by the JMC College of Law for the submission of grades. It is my sincerest hope that you would find the discussions herein both informative and enjoyable. Also, before I forget, I am encouraging all JMC Law students to attend the pre-mock bar lectures, and accordingly, as an added benefit, I will be giving extra credit to my second-year law school students in civil procedure for attending the said lectures, which will be discussed live on, I believe, the Zoom app. With that, we proceed. Now, if memory serves me correctly, last meeting we concluded our discussion on appeals, and consequently, the next topic, which would now be the subject of our present discourse, are the post-judgment remedies that are applicable to judgments which have already become final and executory. But perhaps it would be more prudent if we would discuss first, by way of review, post-judgment remedies in general. Now, in discussing post-judgment remedies in general, we must first classify the judgments into two. First would be judgments which have not yet become final and executory, and accordingly, the other would be those judgments which have already become final and executory. Again, by way of review, when what is referred to are those judgments which have not yet become final and executory, we simply mean that after the judgment has been rendered, the reglementary period of 15 days for the filing of the appeal have not yet lapsed. If it can be recalled, the post-judgment remedies that are available for judgments which have not yet become final and executory, or those post-judgment remedies available within the 15-day reglementary period for the filing of an appeal are: first, a motion for reconsideration under Rule 37. Second, a motion for new trial under the same Rule 37. And lastly, appeals through Rules 40 and 45 by way of notice of appeal or record on appeal or petition for review and certiorari, as the case may be. Corollary thereto, our present discourse would focus mainly on the remedies available to a party after the judgment has already become final and executory. Otherwise stated, the post-judgment remedies available to a party when the reglementary period of 15 days to file an appeal has already lapsed. It has already lapsed, and the latter or the aggrieved party failed to file the appropriate motion for new trial, motion for reconsideration, and or appeal. Now, what are those post-judgment remedies applicable to judgments which have become final and executory? First is a petition for relief from judgment, final orders, or other proceedings under Rule 38. Second, a petition for annulment of judgment under Rule 47. Third, a petition for certiorari under Rule 65 based on grave abuse of discretion amounting to lack or excess of jurisdiction. And lastly, a collateral attack of a palpably void judgment. We would initially tackle the first remedy of petition for relief from judgment, final orders, or other proceedings under Rule 38. Now, what is a petition for relief from judgment, final orders, or other proceedings under Rule 38? What is its basic concept? What is its nature? This is answered in the case of Quelnan versus VHF Philippines, GR number 138500, September 16, 2005, where the Supreme Court had the opportunity to define what a petition for relief is. and it defines a petition for relief as a legal remedy whereby a party seeks to set aside a judgment rendered against him by a court whenever he was unjustly deprived of a hearing or was prevented from taking an appeal because of, take note of this, Casa, take note of this, fraud, accident, mistake, or excusable negligence, fame, or famine. Moreover, in the case of Insular Life Savings and Trust Company versus Runes Jr., GR number 152530, August 12, 2004, citing Mercury Drug Corporation versus Court of Appeals, year 2000. The Supreme Court held that a petition for relief from judgment is an equitable remedy, allowed only in exceptional cases when there is no other available or adequate remedy. However, when a party has another remedy available, either motion for new trial or appeal, and it was not prevented by fraud, accident, mistake, or excusable negligence from filing such a motion or taking such an appeal, he cannot avail himself of this petition. Furthermore, in Manila Electric versus Court of Appeals, 1990, the Supreme Court has categorically stated that a petition for relief is not regarded with favor, and judgment will not be disturbed where the party complaining has, or by exercising proper diligence, would have had an adequate remedy at law, as where petitioner could have proceeded by appeal to vacate or modify the default judgment. Now, simply put, a petition for relief from judgment under Rule 38 is an equitable remedy, allowed in the most exceptional of cases when there is no other available or adequate remedy that will provide or allow for substantial justice. Indeed, courts may set aside final and executory judgments by way of exception to the doctrine of immutability of judgments. You remember that? Now, provided that any of the grounds for the granting of the same petition is present. With that, we proceed to the grounds. What are the grounds for the filing of a petition for relief from judgment? Now, in the determination of the grounds for the filing of a petition for relief from judgment, we consult Rule 38, particularly Sections 1 and 2 thereof. Section 1, Rule 38 of the Rules of Court expressly provides that when a judgment, final order, is entered or any other proceeding is thereafter taken against a party in any court through fraud, accident, mistake, or excusable negligence, he may file in such court and in the same case praying that the judgment, order, or proceeding be set aside. Now, in relation thereto, Section 2 of the same Rule 38 states that when a judgment or final order is rendered by any court in a case and a party thereto by fraud, accident, mistake, or excusable negligence has been prevented from taking an appeal, he may file a petition in such court and in the same case praying that the appeal be given due course. From that, we can deduce that in order for the aggrieved party to file a petition for relief from judgment under Rule 38, the following must concur. Either that a judgment or final order is entered or any other proceeding is thereafter taken against the petitioner through fraud, accident, mistake, or excusable negligence, fame or famine, or when the petitioner has been prevented from taking an appeal by fame or famine. In our present discourse, it would be perhaps prudent to make our discussion on what constitutes fraud, accident, mistake, or excusable negligence, fame or famine, what constitutes it, with more specificity. Now let us first tackle fraud. What is fraud in the context of the grounds for a filing of a petition for relief under Rule 38? This pertains to extrinsic or collateral fraud. The Honorable Supreme Court, in the case of City of Dagupan versus Maramba, GR number 174411, July 2, 2014, had the opportunity to define extrinsic or collateral fraud in the context of a ground in a petition for relief under Rule 38. The Honorable Supreme Court held in that case Where fraud is the ground, the fraud must be extrinsic or collateral. The extrinsic or collateral fraud that invalidates a final judgment must be such that it prevented the unsuccessful party from fully and fairly presenting his case or defense, and the losing party from having an adversarial trial of the issue. There is extrinsic fraud when a party is prevented from fully presenting his case to the court, as when the lawyer connives to defeat or corruptly sells out his client's interest. Extrinsic fraud can be committed by a counsel against his client when the latter is prevented from presenting his case to the court. Now, in the definition of a mistake, in the context of Rule 38, the discussion of the Honorable Supreme Court in the same case is illuminated. The High Court held thus: on the other hand, mistake as used in Rule 38 means mistake of fact. I reiterate, class, mistake of fact and not mistake of law. A wrong choice in legal strategy or mode of procedure will not be considered a mistake for purposes of granting a petition for relief from judgment. Mistake as a ground also does not apply and was never intended to apply to a judicial error which the court might have committed in the trial, since such error may be corrected by means of an appeal. And mistake can be of such nature as to cause substantial injustice to one of the parties. Now, with respect to excusable negligence as a ground for a petition for relief, it requires that the negligence be so gross that ordinary diligence and prudence could not have guarded against it. I repeat, the operative phrase is ordinary diligence and prudence could not have guarded against it. Now, question: what if the negligence was made by the legal counsel? Hello, the lawyer, and not the party. It should be noted that this excusable negligence must also be imputable to the party litigant and not to his or her counsel, whose negligence binds his or her client. Okay, class, ha? It is imputable. The negligence is imputable to the party litigant and not to his counsel. Why? Because the binding effect of counsel's negligence ensures against the resulting uncertainty and tentativeness of proceedings if clients were allowed to merely disown their counsel's conduct. Nevertheless, this court has relaxed this rule on several occasions, such as, number 1, with the reckless or gross negligence of counsel deprives the client of due process of law. Number 2, when the rule's application will result in outright deprivation of the client's liberty and or property. And third, where the interests of justice so require. Again, to reiterate, in the case of Cagayan Economic Zone Authority versus Meridian Vista Gaming Corporation, GR number 149962, January 27, 2016, citing Tuason versus Court of Appeals, 256 CRA 158, 1996, and LTS Philippines Corporation versus Maliwat, 486 Philippines 230, 235, year 2005, the Supreme Court held that generally, relief will not be granted to a party who seeks avoidance from the effects of the judgment when the loss of the remedy at law was due to the negligence of his counsel, because of the time-honored principle that clients are bound by the mistake and negligence of their counsel. Take note, class. Clients are bound by the mistakes and negligence of their counsel. However, in highly meritorious cases, the court may depart from the application of this rule such as when the negligence of the counsel is so gross, so reckless, and so inexcusable that the client is deprived of due process of law, and when adherence thereto would result in the outright deprivation of the client's property, or when the interests of justice so require. The legendary phrase, when the interests of justice so require. Now, from the foregoing discussion, it should be somewhat obvious that the grounds for a petition for relief from judgment, specifically that of fraud, accident, mistake, or excusable negligence, is identical to that of the grounds for a motion for new trial. You remember the grounds for a motion for new trial? Fame or famine. Okay? And practicality would thus dictate that we distinguish between the two remedies. Motion for new trial under Rule 37 and petition for relief under Rule 38. Now, as to the first distinction, a motion for new trial under Rule 37 is available prior to or before the judgment becomes final and executory. And on the other hand, a petition for relief under Rule 38 is available after the judgment becomes final and executory. Secondly, a motion for new trial under Rule 37 applies to judgments or final orders only, while a petition for relief under Rule 38 applies to judgments, final orders, or other proceedings. Okay? And third, the grounds for a motion for new trial does not only involve fraud, accident, mistake, or excusable negligence, but also includes, as one of its grounds, newly discovered evidence. While on the other hand, the grounds for a petition for relief under Rule 38 does not include newly discovered evidence. The fourth distinction involves the prescriptive period for filing. Now, under Rule 37, a motion for new trial is filed within the time for filing of an appeal. And what is that? Or when is that? 15 days. The reglementary period for filing of the appeal is 15 days. While under Rule 38, a petition for relief, which we will thoroughly discuss later, is filed within 60 days from knowledge of the judgment, and or within 6 months from entry of the judgment. Fifth distinction, a motion for new trial once denied cannot be appealed or is not appealable. And generally, the remedy is to appeal the judgment itself, while a petition for relief under Rule 38, if denied, although also unappealable, the correct remedy is the filing of a petition for certiorari under Rule 65, based on grave abuse of discretion amounting to lack or excess of jurisdiction, which also will be discussed later. The sixth distinction involves the nature of the remedies. A motion for new trial is a legal remedy. It is a legal remedy, while a petition for relief, as was earlier stated, is an equitable remedy. And lastly, a motion for new trial under Rule 37 is not required to be verified, while a petition for relief under Rule 38 must be verified. Now, question. If the aggrieved party has filed a motion for new trial or motion for reconsideration, can the same party be allowed to file a petition for relief from judgment after the latter's respective motions has been denied? Now, obviously, the answer is a resounding no. It is a no. In a number of cases, the Supreme Court has held, it has categorically held, that a party who has filed a timely motion for new trial or motion for reconsideration can no longer file a petition for relief from judgment after his motions has been denied. These remedies are mutually exclusive. It is only in appropriate cases where a party aggrieved by the judgment has not been able to file a motion for new trial or motion for reconsideration because of fame or famine that a petition for relief can be filed. Another question. Can a petition for relief be availed of in a civil case involving rules on summary procedure, on the rules or on small claims cases? The answer is no, cannot. Section 19, Paragraph D of the Rules on Summary Procedure, and Section 14, Paragraph D of the 2016 Rules on Small Claims, expressly provide that a petition for relief from judgment is a prohibited pleading. Okay? Now, let us proceed to the period for filing of the petition for relief from judgment. Let's proceed to the period, the reglementary period for the filing of a petition for relief from judgment, as well as its formal requisites. Now, what is the prescriptive period for filing the petition for relief from judgment? What are its formal requisites? Now, this is answered by Section 3, Rule 38 of the Rules on Civil Procedure. It states that a petition provided for in either of the preceding sections of this rule must be verified, filed within 16 days after the petitioner learns of the judgment, final orders, or other proceedings to be set aside, and not more than 6 months after such judgment, final order was entered, or such proceeding was taken, and it must be accompanied by affidavits showing the fraud, accident, mistake, or excusable negligence relied upon. And lastly, the petitioner's good and substantial cause of action or defense, as the case may be. Now, from the foregoing codal provisions, the requirements for the filing of a petition for relief under Rule 38 is clear. That, first, it must be verified. Second, it must comply with the reglementary period. Third, it must be accompanied with affidavits. Affidavits clearly showing the fraud, accident, mistake, or excusable negligence relied upon. And lastly, the affidavit of merit, or the statements of facts constituting the petitioner's good and substantial cause of action or defense, should be attached thereto. It can likewise be gleaned from the foregoing provisions that there are 2 reglementary periods for the filing of a petition for relief. As provided in Section 3, Rule 38 of the Rules of Court, a party filing a petition for relief from judgment must strictly comply with 2 reglementary periods. Let's have a break, class. Let's have a break. And we're back. Okay. Now, what are these 2 reglementary periods for the filing of a petition for relief from judgment? First, the petition must be filed within 60 days from knowledge of the judgment, order, or other proceedings to be set aside. Second, within a fixed period of 6 months from entry of such judgment, order, or proceeding. Now, question: how do we construe the reglementary period provided for by the rules? This is answered by the Supreme Court in the case of TCIS versus Rodriguez, GR number 203642, January 27, 2016. Strict compliance. Strict compliance with these periods is required because a petition for relief from judgment is a final act of liberality on the part of the state, which remedy cannot be allowed to erode any further the fundamental principle that a judgment or order or proceeding must, at some definite time, attain finality in order to finally put an end to litigation. In relation thereto, the Supreme Court has held in the case of Alamana, Islamic Investment Bank of the Philippines versus Contreras, GR number 173168, September 29, 2014, strict compliance with the period stated under Rule 38 stems from the equitable character and nature of the petition for relief. Indeed, relief is only allowed in exceptional cases such as when there is no other available or adequate remedy, as a petition for relief is actually the last chance given by law to litigants to question a final judgment or order. The failure to avail of this final chance within the grace period fixed by the rules is fatal. Now, clear from the jurisprudence I just mentioned that the two prescriptive periods should be complied strictly, and as a consequence thereof, they are not extendable and are never interrupted as a general rule. Remember, class, the prescriptive period or the reglementary periods, two, are not extendable and are never interrupted as a general rule. Now let us proceed to Section 4, Rule 38 of the Rules of Civil Procedure. Section 4, Rule 38 states that the action that the court may take if and when the latter finds the petition for relief submitted to be sufficient in form and substance. What happens if the court finds the petition for relief sufficient in form and substance? The court shall then issue an order requiring the adverse party to answer within 15 days from receipt thereof, and the order shall be served in such a manner as the court may direct, together with the copies of the petition and the accompanying affidavits. Now, a question may be posed: can the petitioner avail of a preliminary injunction during the pendency of the proceedings of the petition for relief? Well, the answer is obviously yes, and it is found in Section 5, Rule 38 of the Rules of Civil Procedure, which provides, the court in which the petition is filed may grant such preliminary injunction as may be necessary for the preservation of the rights of the parties upon the filing by the petitioner of a bond in favor of the adverse party, condition that if the petition is dismissed or the petitioner fails on the trial of the case upon its merits, he will pay the adverse party all damages and costs that may be awarded to him by reason of the issuance of such injunction or the other proceedings following the petition. But such injunction shall not operate to discharge or extinguish any lien which the adverse party may have acquired upon the property of the petitioner. Now, let us proceed to Section 6, Rule 38, or the proceedings after the answer is filed. What happens after the answer to the petition for relief is filed? Section 6, Rule 38 states that after the filing of the answer or the expiration of the period therefore, the court shall hear the petition, and if after such hearing it finds that the allegations thereof are not true, the petition shall be dismissed. But if it finds the allegations to be true, it shall set aside the judgment or final order or other proceeding complained of upon such terms as may be just. Thereafter, the case shall stand as if the judgment, final order, or other proceeding had never been rendered, issued, or taken. The court shall then proceed to hear and determine the case as if a timely motion for new trial or reconsideration had been granted by it. Now, from the foregoing provision, we can gather that after the filing of an answer or expiration of the period thereof, the court shall hear the petition. Now, if the court finds that the allegations are not true, the petition is dismissed. Now, if the court finds that the allegations are true, the court shall set aside the judgment, final order, or other proceeding complained of upon such terms as may be just. Thereafter, the case shall stand as if such judgment or order or other proceeding had never been rendered, issued, or taken, and the court shall then proceed to hear and determine the case as if a timely motion for new trial or reconsideration has been granted by it. Now, what is the remedy of the aggrieved party or the petitioner if the petition for relief under Rule 38 is denied? What happens if the petition for relief under Rule 38 is denied? Can the aggrieved party appeal the denial? The answer is no. You cannot appeal the denial of a petition for relief from judgment under Rule 38. Cannot be appealed. Take note, class, that the remedy of appeal is not available by express provision of the rules of court. On this score, Rule 41, Section 1 of the Rules of Civil Procedure is illuminating, and it categorically states that no appeal may be taken from an order denying a petition for relief or any similar motion seeking relief from judgment. Now, what then is the recourse? It is the filing of a petition for certiorari under Rule 65 of the Rules of Court. Again, to reiterate, the recourse of the aggrieved party when the petition for relief is denied is to file a petition for certiorari under Rule 65 of the Rules of Court. Why? Because there is no other plain, speedy, and adequate remedy in the ordinary course of law. It must, however, be the burden of the petitioner, the one who filed the petition for certiorari, to comply with the requirements that the denial must have been made with the legendary phrase, grave abuse of discretion amounting to lack or excess of jurisdiction. And with that, we conclude this particular section. Now, on the next video, we shall continue our discussion on the remaining post-judgment remedies, particularly the petition for annulment of judgment under Rule 47, a petition for certiorari under Rule 65 based on grave abuse of discretion amounting to lack or excess of jurisdiction, and lastly, a collateral attack of a palpably void judgment. And thereafter, we will begin our discussions on execution. Now, I shall endeavor to upload these videos in earnest when time and opportunity would allow. I would like to express my gratitude for your time in attending the present discourse, and I hope that the discussions have been fruitful and or otherwise productive. Thank you, class. Thank you.